Hi, California Probate Attorney Scott Grossman here, and today I'm answering the question, if I was separated from my spouse when they died, do I still inherit from them? Well, the term separation is really important in this context, and it has a specific legal meaning. And here's why I'm making that point. I've gotten many calls over the years. It's almost always wives who survive their husbands, so I'm just going to use that stereotype. And I'll get a call from a wife who says, my husband and I were separated, he's died, I know he didn't have a will, am I going to inherit? Well, there's a difference between socially being separated and legally being separated. Here's what I mean by that. I will oftentimes hear about how the spouses moved out, there was something, an initial pleading filed in the family law court, asking either for divorce or for separation, and there's been some amount of litigation about that, but nothing's really been resolved in the family law court. Or sometimes I'll hear about people who have moved out and they considered themselves separated, but nothing actually got filed in the family law court. Well, we're talking about a legal proceeding. This sort of social separation doesn't count. You're not separated within the eyes of the law under those circumstances. I'm going to contrast that with a legal separation. And here's what a legal separation means for our purposes today. It means that somebody filed in the family law court a request either for a legal separation or a divorce. And somewhere along the way, during that family law proceeding, the family law court judge issued an order, an actual order of the court that set a date of legal separation. That is the absolute critical analysis in deciding whether or not you're going to inherit. If there was a date of legal separation that was set, then in the eyes of the probate court, you are not husband and wife. You are not going to inherit under those circumstances. Now, that doesn't mean you don't have a right to the property, and it doesn't mean that you won't still be able to litigate for whatever you're supposed to get. If the family law court order actually divided the property, or if the family law court said, I'm setting a date of dissolution and now I'm retaining jurisdiction, then you have to have that fight in the family law court. On the other hand, if what has happened is a date of dissolution was set, but there was no retention of jurisdiction, and that has to be stated specifically in the order, you're then going to be litigating that issue in the probate court. So whether you're going to inherit matters entirely on what has happened in your family law proceeding and the order, if there is an order, what it says.